Zoning Board of Appeals monthly meeting for the month of December 2016. You should all be aware that the proceedings tonight are videotaped for both video and audio. The board tonight, the first item on the agenda is the minutes of the November 17th, 2016 minutes of the meeting. And those meetings are going to be updated, so we will not go forward on those this evening. Those will be forwarded to the next meeting. Next item on the agenda is a letter of continuance for 5 requests from applications number 1022, 1023, 1024, 1025, and 1026. We're in receipt of a letter of request. You read that, please?
Sure. Okay. In accordance with the provisions of Chapter 40A, Section 11, MGL, the Zoning Board of Appeals will hold a public meeting on Thursday, December 15th at the Fuller Meadows School on the following petitions. The application of Judson Deacon Trustees Judd Investment Trust for an appeal under Section 9.1.6 of the Middleton Zoning Bylaw to rescind the order of the Town of Middleton Building Commissioner regarding the property located at 6 Rockaway Road, founded on Assessor's Map 9, Parcel 33. Also for Assessor's Map 9, Parcel 34, Assessor's Map 9, Parcel 57, Assessor's Map 9, Parcel 59, Assessor's Map 9, Parcel 27. And that's from you. And the abutters have been notified. And there is one letter for an attorney. And I think we can...
Continuance.
Yes. Shall we read that too?
Please.
Okay. This is directed to the zoning board from, and it's regarding the Rockaway properties we just cited. Dear Mr. Nazaro and Ms. Brown, the above entitled matters are scheduled for a hearing before the Middleton Zoning Board of Appeals on Thursday, December 15th, 2016. Whereas my client, Judd Deacon, together with Scott Fitzpatrick, the building commissioner, are attempting to resolve this matter on an amicable basis in accordance with the hearing is held on December 1st, 2016 before the Massachusetts Building Code Appeals Board at Milford, Mass. A continuance will be requested in each of the above entitled matters, and that's from Loring Paul Fluke. And that's it.
Okay, the board members that will be sitting on this tonight will be the present board members at the front, and Ann as an alternate. There will be 5 members present.
Ann's not sitting as an alternate, she's sitting as a regular.
She's
The regular member, yeah.
Your regular tonight.
Is there anyone here to speak in favor of this continuance?
Yes. Good evening. My name is Loring Fluke, and we had a meeting on December 1st at the Massachusetts Building Code Appeals Board in Milford, Massachusetts. And at that time, I had occasion to speak with the building commissioner, who has indicated that he desires, if possible, to bring all the buildings that are involved here before you this evening into conformity. I spoke to my client, Mr. Deacon, and Mr. Deacon has also expressed the desire to bring the buildings into conformity. To this end, we have retained an engineer, and as a matter of fact, I am meeting with him in person. He has received all the documentation that has been issued by the building commissioner, and I am reviewing the documentation with him tomorrow morning. To this end, we are going to have a request a meeting with the building commissioner to see if, in fact, we can resolve our differences and bring everything into conformity. In regard to the request for continuance, the Massachusetts Building Code Appeals Board granted us a continuance based upon the basis that we would file the necessary documentation with the town of Middleton by January 15th. The matter before the appeals board was in fact continued to an indefinite date in February. And to that end, we are going to request a continuance to give us the opportunity to sit down with the building commissioner and attempt to resolve our differences without further delay in this matter. Thank you.
Thank you. Anyone else here to speak in favor of the motion, the continuance? Is there anyone here to speak in opposition of the continuance? Commissioner?
Mr. Chairman, there was a meeting, as Attorney Fluke referred to, on December 1st. At that meeting, it was made very clear what the path to compliance for those properties are. They require filing for zoning approvals for all 5 properties. Continuing this matter does not help that. I feel this hearing should go forward tonight. This hearing is solely based on the orders written and the file is as it exists today of the legal uses of the property. What Mr. Fluke is looking to do is Mr. Fluke is looking to come in and apply for zoning approval for what the properties are currently being used as, despite what the legal record has them listed as. It's a separate hearing that's required on each property. Tonight's hearing is solely based on whether or not the orders I wrote was correct.
Thank you. Counsel?
And the Commissioner is absolutely correct. The issue before you tonight is whether at the time these orders were issued, whether the building was in noncompliance with the zoning bylaw. What Mr. Fluke is alluding to is requests for zoning relief, to get relief from the requirements, because there's absolutely no question that it's not in compliance with the zoning bylaw. In fact, this summer we went through a 4-day trial in Newburyport Superior Court, and the judge agreed that the Candlelight, which is the only property at issue, was in not compliance with the zoning bylaw. So this is similar how you ended up the School Street hearing, where you entered a decision based on the merits of whether the order was correct and you affirmed it, or whether the order of the commissioner was incorrect and you reversed it. And I'm asking that you do the same thing tonight. And we're all here for that matter.
Well, I agree. The only question before the board this evening is, did the building commissioner act reasonably and prudently and within the color of law when he issued the letter directed to the question of the appellant in this question? And that's, I think that is the question before the board. Anyone else to speak in opposition? Any discussion from the board?
I move to deny the motion to continuance, the motion to continue and proceed on the merits of the matter.
Motion is made to deny the request for continuance. Is there a second?
Second.
Second. All those in favor?
Aye.
And I vote aye. The motion for continuance is disallowed. The next item is the applications in reference to these same properties. And we'll take them one at a time, starting with application 1022. Anyone here to speak in favor of this application?
What's the address of that property, please?
The address is 6 Rockaway Road, in the middle.
My name is Loring Fluke. I appear on behalf of Mr. Deacon. And in regard to Mr. Deacon, we have filed an affidavit. And I'm going to read from a portion of that affidavit, which has been filed with this board. And it indicates here that Mr. Deacon purchased this property on December 7, 1977. At the time he purchased the property and all time since then, the property has been a 4-unit, multi-family residential dwelling or rooming house, and has always been so used. During the years that he owned the property, it's been inspected on multiple occasions by then-serving building commissioner of the town of Middleton, as well as other officials. And with minor exceptions not relevant to these proceedings, the property has always passed inspection. In addition, to Mr. Deacon's knowledge, this property has never been a single-family residence, and the fact that it contained 2 floors and 12 rooms, namely 4 bedrooms, 4 bathrooms, 4 kitchens, belies the town's suggestion that the property was designed, built, or used as a single-family residence. Thank you.
You want to be heard, sir?
Well, there's 3 electrical meters on the building. It's never been a single family. I bought it the way it is, and I've never had a problem with anybody until now. And I've got affidavits and signed statements from people who have lived there, whose aunt used to live there, and her brother lived there, and she lived there. And I got an affidavit from a contractor who did some work in the house back in the 50s. I got another affidavit that the septic guy said it was a multifamily.
Sure, all these affidavits are fine, but I don't see them in the packet. They're not before the board. So when there's no paperwork to support what you're saying,
Would you take one
you're
now?
welcome to
Would you take
testify, but
Would you take one now?
there's a cutoff date of submitting papers to the board, sir. And you're beyond that cutoff date, so it isn't appropriate for the board to take them now. The board requires time to look at affidavits or any other paperwork that you're going to submit to us and be able to determine and make an opinion on them so that we can address it correctly here when we sit at the meeting. And you're outside of that date. It has to be submitted usually within a week prior to the meeting. So I appreciate the fact that you're saying you have affidavits, and I don't doubt that you do. They're not before the board, were not submitted within the proper time frame.
Thank you.
Thank you, sir.
Anyone else to speak in favor of the application? If not, anybody to speak in opposition to the application? Please, Commissioner.
The property was inspected on October 15th. The inspections were ordered as part of the legal case in Essex Superior Court on another one of the properties as part of the counterclaim, if I'm speaking correctly. We were allowed access to inspect the 5 properties. Myself, Chief Martinook, Lieutenant Kessel from the Fire Department performed the inspection, documented everything at the property. Second floor unit appeared to be a 1-bedroom apartment. There appeared to be 3 smaller units, whether they were studios or 1-bedrooms on the first floor. After completing the inspection, I went back and reviewed the file. In the file is a building permit application from September of 1983 requesting a building permit for a single-family dwelling. Subsequently, the work was completed, and I believe in April of 1985, there was an occupancy permit issued for the dwelling. The file was clear. Building permit was pulled for a single-family dwelling, and the occupancy permit was issued a little over a year later for a single-family dwelling.
Who applied for that building permit?
It's listed as Judson Deacon, owner.
Thank you.
Anyone else? Counsel?
To give you background, after April of 2014, Mr. Deacon would not allow the building department to go into any of his properties up there. And the trial in Newburyport Superior Court had 2 components. One was whether there was zoning violations at the Candlelight, which entitled the town to reject any building permits. And the other was a counterclaim to get a court order allowing the town of Middleton to inspect all of the properties, which the town of Middleton has a right to do under the state building code in any event, but that was refused, and that was allowed in. And as part of the decision in that Superior Court lawsuit, Judge Welch agreed with the town that there was no grandfathering, if you will, of zoning violations as to uses unless there was building permits granted. And at the trial, Mr. Deacon was unable to come up with any building permits. So frankly, any statements you hear tonight in any of the properties about how many inspections were done and that everything was fine and everything was okay, and I've been doing this for years, is completely irrelevant unless there's a building permit issued and unless the property is being used pursuant to the terms of that building permit. So, as the commissioner has indicated, the only building permit he has was a building permit that was issued to Mr. Deacon, which is contrary to the affidavit that he's put before you in this case. And that building permit gives him the right to use that property as a single-family dwelling, and therefore that's all he can use that property as a single-family dwelling.
I will add, as a 4-unit dwelling, it would have been subject to 110 inspections required by the state building code that could take place anywhere between a 1-year and a 5-year interval based on the inspector's determination once you inspect the building. It's very similar to the ones we do for the restaurants annually, condo buildings, the schools we do annually. Multi-unit buildings, anything over a 2-family, are subject to that inspection. There are no records of any 110 inspections being done at that property. Mr. Deacon is very familiar with that process because 319, the motel, was done annually.
And there were no inspections there?
There was no annual inspections or 110 inspections on file for 6 Rockaway.
Thank you. Anyone else to speak in opposition? Any discussion from the board? Ann,
Are
please.
people living in these, and are they safe? I mean, is there egress, are there sprinklers, or is this a concern for people living there currently?
Most of the units we inspected were occupied. We did note which ones were occupied, which ones weren't occupied. There were 2 units between the 5 properties, not this structure, that had egress concerns. They were cited under the dangerous and unsafe statute, which has a different route of appeal, which, to the best of my knowledge, was never filed. Those appeals on a dangerous and unsafe order go straight to the Superior Court. There was 2 units that were cited under that, not in this structure, though. This structure, at 6 Rockaway, 4 units. The second floor had 2 means of egress, and each of the first floor units had a door open to the outside, and I believe all 3 enter to the rear egress hallway. I think Phil is Mr. Deacon's staff who showed us through. So that unit did have it. There are no sprinklers in that building.
Okay, thank you.
Anyone else? Any other board members have any discussion? There being,
Yeah.
excuse me, go ahead.
Who went with you when you conducted the inspections?
Chief Martinook of the Fire Department and Lieutenant Kessel.
And who was there on behalf of Mr. Deacon?
Phil Karate.
And who is he?
Not sure of his title. I believe he's an employee of Mr. Deacon's.
And was Mr. Deacon his attorney present?
No. Phil is here tonight.
Okay.
Anyone else? There being no further discussion,
There is one
you have to get up and come to the microphone, sir, so that, as I advised you when we started, this is being recorded, so
Okay.
it's helpful so everybody can hear what you're saying.
Thank you. My part-time employee has brought these inspectors through these buildings many times for the last 7 years. They've been going through all these buildings. So it's not that we ever stopped them from ever going in. The only reason I ever stopped them from going in is because they told me they were going to condemn all my buildings all at once, why I just had the fire. That's the only reason I stopped them from going in. All the other times, I let them go in anytime they wanted to go in. And I can verify that with Phil back here. He can come up to that speaker and swear under oath that he let them in and had them all inspected and everything else. So that's not true. Thank you, sir.
Thank you, sir.
Tom wants to say something.
Yep.
Again, I mean, at the trial, there was discussions that when inspections were made, not every room was inspected. And again, it's completely irrelevant whether there were inspections or not. It's a simple question. Is there a building permit in the file? And is the property now being used pursuant to the terms of the building permits that's in the file? Mr. Deacon at the trial alluded to some other documentations that apparently get destroyed in some type of flood over there. There was, I believe at the trial, there was 77 exhibits of evidence introduced, and none of those exhibits were exhibits that supported Mr. Deacon's contention that there was some building permits floating around somewhere that allowed him to use any of these properties the way he was using it. And there not only apparently was those building permits that he had that nobody's ever seen destroyed by a flood, but those so-called building permits were not in the building commissioner's file, and they were not in the zoning board's file, because some of those would have been issued as a result of special permits, and there was no record of those items either. So it's a very simple question. If somebody's claiming he's grandfathered in, then there has to be a building permit granting him the right to use the property for those reasons, and that's not present here.
Excuse me, there's no building permits that pertain to the use of the property as it is today.
A multifamily, no.
Right. The commissioner told you about the only building permit that is.
The most recent permit was for a single family, and it was obtained by Mr. Deacon.
Correct.
Yes.
Based on our records.
Yes.
There being no further discussion, I'll make a motion. I move that the board vote to affirm the order of the building commissioner in this appeal of his decision. And I incorporate into this motion a letter from the building commissioner, the town of Middleton, to 8 Rockaway Road, dated September 30th, 2016, in its entirety. We've heard testimony tonight from the applicant, his attorney, the building commissioner, the town council. In addition, we have reviewed documentation presented by the applicant's counsel, as well as reviewed a Superior Court decision concerning the premises that are the subject of the matter in the appeals before us tonight. And this decision questions the credibility of the applicant's testimony about why he may disregard the ZBA restrictions, as well as struck down arguments advanced by his counsel as to why he did not have to comply with zoning requirements on these premises. Based upon that testimony and evidence presented, it is clear that the applicant has failed to demonstrate any reason why said order of the building commissioner should be reversed by this board. It is also clear that there are numerous violations of the Middleton zoning bylaw and state building code, as noted in the building commissioner's order. Based upon the foregoing, I move that we affirm the order of the building commissioner. Is there a second?
I'll second it.
Motion is made and second. All those in favor?
Aye.
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 The vote is unanimous. The request is denied, and the building commissioner's letter is upheld. Next item on the agenda is application 1023 for property at 8 Rockaway Road. Is there anyone here to testify in favor of this application?
Good evening, my name is Loring Fluke, and I appear...
What was the,
8 Rockaway.
8 Rockaway.
1023.
1023.
1023 should be 329.
329.
9
Yeah,
North
there
Main.
is 329.
I'm sorry, 329 North Main Street.
Hold on.
Everybody got that?
I have 319 North Main Street. It should be 329.
329.
319 would be the one after.
1023.
Oh, 329, I got it. Okay, yep, I got it. I'm on it.
Okay. Are we all together?
There, good now. All right, so 329 North Main.
Can we agree it's
I apologize, counsel, I gave you the wrong address. It's 399,
No, 320.
329.
329 on application 1023, which is before us at this time.
Thank you. Mr. Deacon has filed an affidavit also with this board. The pertinent section of the board of this affidavit is that he purchased the property on or about May 29 of 1985. At the time that he purchased the property and all time since then, this property has been a 7-unit multifamily residential dwelling and has been so used. During the years that he's owned the property, it's been inspected on multiple occasions by the then-serving building commissioner of the town of Middleton. And by other officials. And with minor exceptions not relevant to the proceedings, the property has always passed inspection. To Mr. Deacon's knowledge, this property has never been a single-family residence, and the fact that it contains 3 floors and 21 rooms belies the town's suggestion that the property was designed, built, or used as a single-family residence. Thank you.
Anyone else to speak in favor?
We had a fire there. The
Want to
building,
identify yourself? sir?
Judson Deacon.
Thank you.
We had a fire there. The building inspector made me get drawings from an architect back in 1985. We reconditioned the building again, $28,000, put it back in operations. Building inspector knew the history of the building. He gave us permission to reoccupy, gave it an occupancy permit, and we operated for the next 31 years without a problem. We still have, and I have affidavits that people live there. I obviously can't give them to you now, but I have them. They're stamped, and there's more than 3. So all I can tell you, the building inspector gave us permission to reoccupy that building with an occupancy permit. And if he doesn't know what's going on, I'm certainly not the one. He was hired by your town. He knew the history of the building, and he gave us the occupancy to reoccupy that building 31 years ago. His name was Mr. Cashman. Thank you, sir.
Thank you. Anyone else to speak in favor of the application?
How you doing? I'm Phil Crotty. I used to be the full-time maintenance manager until the hotel was closed. I worked with Mr. Deacon part-time. I have a hard time understanding why we're even here. They brought criminal charges against Mr. Deacon in 2016. There wasn't enough evidence found in the criminal court case that it was dismissed. He brought him the 9.1.3 and 9.1.4 against all these buildings. That criminal case was dismissed in court. Well, I don't understand why we're even here. If they brought criminal charges and this was dismissed in a criminal court, why are we here in front of this board at all?
Mr. Deacon's attorney filed an application. That's why we're here.
They filed charges against us.
That's got nothing to do with the application that's before us. We have an application that was filed by Mr. Deacon's attorney.
The zoning things were thrown
That's
out
why we're here.
in criminal court. They were dismissed in criminal court.
Yeah, that's got nothing to do with the hearing before us, sir. We're here because of an application filed by Mr. Deacon's attorney.
We only filed an application because Mr. Scott, excuse me, I'm sorry, filed charges against us.
Well, clarification.
Let's clarify it, yeah.
Yeah, we did not file charges. These are zoning enforcement and building code enforcement orders issued after an inspection that was part of a counterclaim of a civil suit in Essex Superior Court.
That answer your question, sir?
No, it really doesn't. I mean, if criminal charges were filed, that's the last resort as far as the code book is concerned.
Yeah.
Those were thrown out.
criminal charges aren't-
Separate matter. Do you have anything to say about his appeal of the building commissioner's order? That's what we're here for today.
Obviously not.
Thank you. Anybody here to speak against the application? Commissioner?
Myself, Lieutenant Kessel, and Chief Martinook of the Fire Department inspected the properties as a result of the counterclaim on the Essex Superior Court case. After the inspection, we came up with, the first floor had 2 apartments on it. I believe they were 1-bedroom apartments. Second floor had 4 units, Two were studio apartments. One appeared to be a one-bedroom, and one appeared to be a rooming unit. And the third floor, which we weren't given access to, there was no key, was described as a one-bedroom unit. The fire alarm system in this building was in trouble at the time of inspection. I went back and reviewed the file. In January of 1986, a building permit was issued to reconstruct a single-family dwelling from fire damage, and subsequently the work was completed, and an occupancy permit to occupy the dwelling was issued in September of 1986.
Who signed that occupancy permit?
The commissioner or the inspector of buildings at the time looks like Mr. Cashman. The
And that
permit
was-
was issued to Judson Deacon.
And that was for a single-family dwelling?
Single-family dwelling.
Thank you. And that's in the file?
Correct. And once again, there is no record of any 110 inspections being performed on this property, which would have been required as a multi-unit building. And I also would like to point out, as part of the research into the legal use of the property, checking Mr. Deacon's website for his motel, all 5 buildings are shown on the map of the motel with different names on them, and he's advertising over 100 rooms.
Thank you. Counsel?
And he's advertising over 100 rooms. And when we get through this whole process, I think you're going to see that he's got building permits that total something like 55 units altogether. So essentially, there's 45 illegal units in this whole complex. Earlier, I read excerpts from a decision, and what I was referencing was a judgment of the Newburyport Superior Court entered on September 26, 2016, in docket number 1577CV00446. And I'll leave a copy tonight so you have that in the record. But in addition to, and Mr. Crotty was present during this 4-day trial, in addition to the judge repeatedly acknowledging that there were zoning violations at the Candlelight, his decision on page 4 references that Mr. Deacon's testimony that the building commissioner gave him some sort of oral permission to disregard the ZBA's restrictions is not credible in the slightest. In any event, the building commissioner cannot legally contradict the ZBA's decision. And I will point out that this is the second time tonight that you have an affidavit in front of you telling you that Mr. Deacon bought this property as a 4-family, and yet there's a building permit issued to him as a single-family dwelling.
Thank you, Counsel. Anyone else to speak in opposition? Any discussion from the board?
Scott, I know you can't speak about past practice, but is there, based on your extensive experience as a building commissioner, and based on practice within the community of building inspectors, when you go out and conduct an inspection, is there a form that you fill out? Do you give something to the owner of the property? Do you keep something in the file for the town? What do you do?
For a building inspection, we not only do we sign the building cards, we have a 2- or 3-part form that we make notes about the inspection. One's given to the applicant. The other is brought back to the file. As far as a 110 inspection, which was the annual or biannual or whatever the housing unit would have qualified for, we have a 8.5 by 11 sheet that has 20 or 30 different items that we go through and we check off, and that gets placed in the file. There are no records of annuals. There are no annual inspection reports in the file for this property.
Thank you.
It's actually a building code requirement to document your inspection in writing.
Thank you.
So again, I come back to my question from the last building. So these are occupied buildings, and are the electrical systems correct? Are there we don't know any of that.
I don't know.
So
This
are these
is one of-
systems being overloaded to where it's dangerous for people?
Well, and you mentioned something about the fire alarm is in trouble.
was in trouble. The fire alarm systems, when there's a problem, with the low voltage systems, when there's a problem with them, there's a trouble light that'll show. It could be a bad device, could be a short in the system. It means it's not working properly. Any more detail than that, I'd defer to the chief who is here tonight. This is also one of the structures that was cited under the dangerous and unsafe section of the building code because we weren't able to access the third floor unit, and it appeared to us the third floor unit was being served by one means of egress.
So how many people are living there?
There was 2 one-bedroom apartments on the first floor, 2 studios on the second floor, what appeared to be a one-bedroom on the second floor, a rooming unit on the second floor, and then the one-bedroom apartment on the third floor.
That are all currently occupied to the best of your knowledge?
We did not enter looking at the building from the street, the first floor right unit. We didn't enter that one. There was no keys available. And we didn't enter the third floor unit.
Attorney Fluke, how many of those units are occupied at this address? So how many people are living at that address right now?
Probably about 9 people. Judson Deacon.
May be allowed to continue on. Mr. Deacon.
I have a narrative description from the town after the building. This parcel contains 1.5 acres, apartments 4 to 8 units. Existing building built about 1930. Shingle exterior, asphalt roof, 6 bathrooms, 6 this, half baths, 25 rooms. Nothing was hidden from the town when Mr. Cashman gave me the occupancy permit.
And what is the date of that, sir?
I'll hang it.
Well, what Mr. Deacon's reading from is the assessor's records. Assessor's records do not
okay.
determine legal use. Assessors tax what is there, whether it's legal or not.
Very good.
Mr. Chairman.
I don't want the board to blame me if the building inspector made a mistake. It's not my mistake, it's the building inspector's mistake. I didn't approve the building, he did. He knew the history of the building. He knew it was a multi-unit building when he approved it. Thank you, sir.
And if I may answer this question, I know we go through it all the time with the 110 inspections. Hallways being cleared, exit signs, fire extinguishers, fire alarms, anything that has to do with fire or escape goes through those. So if you have people living there and they're not going through those procedures and not complying with the 110 inspection, I got to believe that's somewhat dangerous, to say the least. I know you guys, when they come in to look at our locations, I mean, they turn everything over to make sure that everything is in its...
You can't just keep popping up and down here.
in its proper state, so that no one gets hurt at the end of the day.
That's because they love you.
Huh? But and that's something. I mean, with that many people living there. Anyways, that's how intense, from my experience, 110 is.
Is that a building code issue, state building code issue, more than an issue for us, the safety issues?
Yeah, 110 inspections are building code they're a building code requirement. What it would have done is, if they were being done, it would have proved that inspections that they claim have happened and were documented. We don't have that in the file.
For
Because our file-
any year at all?
We don't have any for that building because they're not required on single-family dwellings.
Oh, I see.
And our records indicate it's a single-family dwelling.
So we don't know why
Inspectors
it was
are
issued that
Correct.
way. We don't know why it was issued that way.
Because it
But
was applied
meanwhile,
for that way.
an unsafe condition continues to exist
Correct.
because those inspections aren't being done to catch the unsafe living conditions because they're in violation of the law.
Multiple families.
Well, the
living.
inspections themselves were blocked from April of 2014 on. They were
The
refused.
110 inspections were never applied for.
I was going to ask you that question. Was ever did they ever do a 110 inspection? On the property?
The only, my search of the records, I've been here since August, The only property that was applied for and inspected was 319, which was the motel property.
That had a 110.
Yes.
Okay, and what was the last date of that?
That one was 2014, I believe, shortly before it was shut down.
2014.
14, yeah.
But after that, there was a fire in 2014 at the Candlelight, and we had a big meeting at Town Hall. And as a result of that meeting, the town, specifically the building commissioner, wanted to inspect every single building that Mr. Deacon owned up there. And Mr. Deacon absolutely refused to allow that to happen. That's in the judge's decision also, that he refused that after April of 2014.
May I add one thing here to what council
Certainly,
has,
Counsel.
with your permission?
Please, come up
Thank
to
you.
the microphone.
Let me indicate one further thing to you, please, that following that particular meeting, or prior to that meeting, there was a letter from town council, and town council indicated that he would not grant or recommend in any way whatsoever, or the town of Middleton would not, in fact, issue a building permit for the motel which sustained fire damage unless every piece of property owned by Mr. Deacon was inspected. In other words, he was making it conditional that every parcel of property, whether it was related to the fire or not to the fire, had to be inspected before any building permit was going to be issued by the town. And that is entirely illegal. Thank you.
And I did issue that letter, and as the Candlelight never complied with zoning, that issue was never reached. The reason for that letter is what we see in the news going on in Oakland.
Please.
Right.
You're out of order, sir. Please.
Excuse me,
Take
Mr.
a
Cride, I'm
seat.
speaking.
I didn't say a word. Didn't interrupt you.
The concern the town always had, that what's going on now in Oakland was going to happen at the Candlelight. And there was an inspection done at the Candlelight, and the chief was there also. And it was a small minor fire at the Candlelight, thank God, because that place was a maze, and I don't see how the fire department would have been able to put anything out up there. And there was, probably 55 people living in it at the time. But that's what is driving the whole situation. The town wants this brought up to code. There's people living there. There's over 45 units being rented illegally. We want the proper inspections done. We want the proper sprinkling done. If that's required, we want this brought up to code. So what happened in Oakland does not happen in Middleton.
So there are no plans on record for any of these buildings except as single-family homes. But, so are they all like rabbit warrens and
Well, the
hallways?
Candlelight's a little different. We'll get to the Candlelight itself.
But these multi-unit, these 10-unit buildings, are the hallways lit? Are
There's, we didn't check emergency lighting, exit lighting. They're common hallways. There are some fire doors installed. As I said, the fire alarm system was installed, but in trouble. Trouble means we don't know if it's going to function properly.
Because we don't know what the wiring situation is in
and-
those houses.
Basically, at our December 1st meeting, the path to compliance was laid out, and the path to compliance was, first, you need to gain zoning approval through the ZBA. It was made clear that this hearing was not for zoning approval. This hearing was for whether or not I was correct in writing the orders. File for zoning approval. If they gained zoning approval, the next step would have been a Chapter 34 code review, where the applicant would hire a architect or engineer who would study the buildings, what's on there, what's on site, what's in place, compare it to the requirements to convert it to the multi-unit building, put a plan together on what needs to be done, what doesn't need to be done, the work would need to be done, and then occupancy granted. That was the path to compliance. It was pretty, we went on record at the Building Code Board of Appeals laying it out that way. Earlier tonight, I believe.
Commissioner, I have a question for you. Let's go back in time. There were permits to build single families, in some cases, two families. but yet we have something that's much more than that there today. How did that happen?
I don't know.
You weren't here at the time, but
was not,
how
no.
did that happen? How do you come up with this and end up with that? And that's why we're here today. That's my question.
When we explain,
There's a question I have as a board member.
fine.
All right, but that doesn't make it right.
You want an explanation?
I'd like to have an explanation.
Nope.
Name is Judson Deacon.
I'm not quite finished yet.
Okay.
I'm not quite finished yet, if I may.
Yeah.
What do we got?
Well, just for the record, what Mr. Deacon handed you was something that we have in our files. There are some documents that we have that agree with each other, and this is one that says that he has permission to rebuild a single-family dwelling in 1986.
Is that the January 6th, 1986?
Yes. So obviously it wasn't a four-family dwelling when he bought the property.
Right, and what I'm saying here tonight,
Because it says rebuild?
Correct.
he rebuilt a single family. But my question is, how did it go from where we are with a single, in some cases a two-family, to this multi-family situation with no explanation to it? Now, it's not saying it's right. As a matter of fact, we know it's wrong. But
Well,
in the point, I'm thinking, I mean, whatever you did, you got away with it up to this point.
Right.
And now we're at a stage where we're figuring out how did we get from A to B.
When I applied for the permit, I didn't write the permit out. The building inspector.
But that says a single family, in all due respect. You've got multi-families there, so
That's
how does
correct.
that work? You understand?
it's the old DGDI defense. The dead guy did it. Okay, so what we're going to say is that some unnamed building inspector gave me permission to do it, but
Doesn't make it right.
as noted in the judge's decision, a building commissioner cannot legally contradict the CBA decision or CBA rules, and unless there's any building permit in the file granting permission to build, then the use is not grandfathered in, so it's irrelevant.
And Attorney Fallon, I agree with you.
Yep.
My only question was, I had two cars in the garage, now I got 10. How did they get there? I only bought two. You know, there's something that went wrong here, and I understand what went wrong.
You violate the zoning law.
Well, you violated it.
That's how you
and-
get
and-
there.
and it's a shame to be at this point at this time, but I think, if I may, that you kind of reap the harvest from there to here now. I think that party is over with. You
Mr.
understand?
Catherine wouldn't have given me an occupancy permit if I was in violation of all these rules.
We don't know that.
This house has fire extinguishers, emergency lights, exit lights, and fire doors on the second floor corridors and stuff. This was approved by him, and he was a good man.
I'm not disputing his goodness
he
or his
knew the
badness.
history of the house.
All I'm saying is making one simple point, and it is a simple point for everybody that's in this room. You started off with a permit that said one single family or a two-family, whichever case. You have multiple units in those same areas. Something happened there.
The guy made a mistake, but they all signed
I
off
don't
on it.
think-
All of them signed off on it.
I wasn't there, so I can't say
of course you
anybody made a mistake. I think whoever stretched it from A to B, C and D, and made it that big, made the mistake. That's how I feel.
I guess what I don't understand is you're obviously in violation. You want to come into, you admitted at the beginning through your attorney that you've acknowledged that you want to bring each of these properties into compliance. So by acknowledging that, you're admitting that you're in violation in each one of these properties. So why are you wasting time going through this appeal process instead of focusing your energy on bringing the properties into compliance?
The property was there before zoning. It was 6 to 9 units on both units of these houses. They were there before zoning.
You've acknowledged, your attorney has acknowledged that you're not in compliance on each and every one of these properties. He opened his opening statement to this board today. He said that he acknowledges that his client wants to bring each property into compliance which suggests that each property is not in compliance.
But we never stated as to what extent it's not in compliance.
It doesn't matter. It doesn't matter to what extent.
It may be an insignificant aspect.
It's
But
still-
nevertheless, that's the whole reason.
You can't be a
as to
little bit
why
pregnant.
we asked for a continuance.
That's exactly, I was going to,
That's
They got it
the rest
right.
out of my notes.
That's the reason why we asked for a continuance.
That's good.
The guy gave me the permission, gave me to occupy, it was there before before zoning, I don't know what else to tell you.
Okay, we're going to go through these, let's get through these here, Jim.
So we
Yes,
go on.
We're going to go on for each one of these here.
Good, I'll tell you.
Huh?
She's good.
Yeah, she's real good. Yeah.
Any other discussion? There being no further discussion, I'll make a motion.
Oh, you want me to make a motion?
Let's just run through these here. We're wasting a lot of time.
I move that the board vote to affirm the order of the building commissioner and the appeal of his decision. I incorporate into my motion a letter from the town of Middleton, the building commissioner, in reference to 319 North Main Street dated October 13th, 2016. We've heard the testimony tonight of the applicant, the attorney, the building commissioner, and town council. In addition, we have reviewed the documentation presented in the applicant's counsel, as well as reviewing a Superior Court decision concerning the premises that are the subject of the matter in the appeal before us tonight. And this decision questions the credibility of the applicant's testimony about why he may disregard the ZBA restrictions, as well as struck down arguments advanced by his counsel as to why he did not have to comply with zoning requirements on these premises. Based upon this testimony, evidence presented, it is clear that the applicant has failed to demonstrate any reason why said order of the building commissioner should be reversed by this board. It is also clear that there are numerous violations of the Middleton zoning bylaw and state building code, as noted in the building commissioner's order. Based on the foregoing, I move that we affirm the order. Is there a second?
Second.
Motion is made and second. All those in favor?
Aye.
Aye.
Aye. Nick?
Yeah, aye. I
I
made the
got you
motion.
too, Barbara? Yes.
Okay.
Motion is unanimous. The application is denied. Next item on the agenda,
24. Same thing.
no, she doesn't want to. She wants to move forward. Excuse me. Next item on the agenda is application 1025.
24.
2-4. 2-4.
Did I get, wasn't that the one we just did?
319, no.
This one is the
319.
Three more to do.
This is the hotel. Okay, 24, excuse me. And that would be 319 North Main Street. Anyone here to speak in favor of the application? That's right, I marked that hotel.
Good evening, Loring Fluke, attorney for the applicant. We have filed an affidavit, Judson I. Deacon, which you have before you. The pertinent portions of that particular affidavit is that he purchased the property on or about June 1 of 1976. During the years that he's owned the property, it has never been used as a multifamily dwelling, contrary to the building commissioner's allegation. It's always been used as a motel. The motel does not contain 68 units, contrary to the building commissioner's allegations. It does contain 64 units and has contained 64 units since at least 1986. And during the years, it's been inspected on multiple occasions by the then-serving building commissioner of the town of Middleton, the fire department, the health department, and with minor exceptions, has always passed the inspection. The entire matter here, in terms of the fire at the what's the address of the street?
319.
319.
319 North Main Street.
North Main
Council.
Street. This property has always passed inspection. Matter of fact, the last inspection was in 2014, and it did pass inspection. We've had a whole series of inspections throughout the years at the motel, and it always has passed inspections. The problem in this particular situation, and where this matter has gone entirely astray, was that there was a fire at the motel. And the fire was, in terms of the amount of damage, was a relatively minor fire in the sense of approximately $6,000 or $7,000. And that's how this whole thing blew up, in the sense that we sought a building permit, and that was denied. And that's how we spent 4 days of trial in the Essex Superior Court in Newburyport, trying this particular matter. Our basis was that under the town zoning laws, if there is a catastrophe, we are entitled to rebuild the premises, and we are entitled to a building permit. The court did rule in this matter that a $6,000 fire was not a catastrophe, and that's how this entire problem came about. It's to be noted that in other communities, but you're not governed by this, that they talk about catastrophe and fire, and that entitles you to a building permit. Unfortunately, from our aspect, is that the bylaws of the town of Middleton talk about only the aspect of catastrophe. They don't add the word fire. And the court did issue a ruling and indicating, in fact, that they felt that a $6,000 fire was not a catastrophe. Thank you.
Anyone else to speak in favor of the application? Anyone here to speak in opposition to the application? Counsel?
Just to set that matter in context, Mr. Deacon came in for a building permit, and the town rejected the building permit because under the town zoning bylaws, a building commissioner is prohibited from issuing any permit on any property that doesn't comply with zoning. Mr. Deacon, instead of complying with zoning, took the route that he was going to argue that under a different provision, this was a catastrophe that gave him the right to rebuild and receive a building permit, notwithstanding zoning violations. The court completely disagreed with that. I think it's interesting that Mr. Deacon's affidavit focuses on his argument that the motel does not contain 68 units. It contains 64 units. The question before you is, he's got building permits for 54 units. So the question is whether he has 54 and under, not 68 and under. I mean, 64, he's conceding that there is a violation. And the judge ruled specifically on the candlelights and said that it was in violation of zoning because all these inspections showed that they had approval for 54 units and that there was way more than 54 units there, in addition to the so-called hydrotherapy units that were located in the cellar.
Thank you, Counsel. Do you have anything?
Yeah, a very detailed inspection of the property was completed by myself, my local inspector, Fire Chief Martinook, and Lieutenant Kessel. After the inspection, we were able to go back and review the records. The records indicate the zoning approval for 54 units on the property. We've counted a total of 68 on the property, not including the 8 hydrotherapy units in the basement. We've further gone and researched the plans we have on file, that out of the 54 units, only 51 are constructed where they're supposed to be. There's 5 units constructed on the 3rd floor of the motel. These units have no windows. They're served by a spiral staircase, which is not allowed on anything above a two-family home. There's no permits for them. There's another 5 units in what's called the 400 wing. The 400 wing is the pool addition. All these additions came in front of the board at some point for approval. That section's not supposed to have any units in it. There's 4 motel rooms and a 1-bedroom apartment in that section. The second floor of the main wing, supposed to, by the zoning approval, there was 12 units. By the building plan submitted, there should be 11. There's 19 up there. So basically, what we've been able to do is track back to where the units are supposed to be, and I can only come up, although there was zoning approval for 54, only 51 of the ones that were supposed to be constructed were, and then units were constructed in various portions of the motel that don't match the plans.
Let me stop you for a minute.
Yeah.
Did he go outside of a footprint?
No.
Within the footprint?
Within the footprint, yeah. All the plans on file indicate the area of the second floor of the pool wing, which was constructed with board approval, was supposed to be what I'll refer to as common space. That has 5 units now. There's nothing shown for the third floor, serious building code violations, and it's a little tricky to get the count. There's connecting doors between units.
Basically, help me understand this. Basically, he took the footprint and shuffled the space inside.
Exactly. Main wing on the first floor, the building plans and the zoning approvals talk about 12 units. The zoning approval talks about 12 units. The building plan talks about 11, and there's 19 there.
Just so I can be sure what you're saying, he applied for a permit to put in the swimming pool area with common area around it, then got an inspection on that, and then after the inspection, added additional units?
I can't tell you when they were added. All I can speak to is the permit in the file and what.
The swimming pool was inspected, right?
I would assume so.
Yeah.
The basement, what's referred to as the cave units. The cave units were granted a special permit by this board with a 1-year time frame on it. The permit expired after 1 year. That was granted in April of '84.
And that was for motel guests only.
I believe in the trial in Essex Superior Court, it was admitted that it was being operated in violation of the special permit to people who were not guests.
And that there were beds there, even though in the minutes of the special permit hearing before the ZBA, it was represented that there would be no beds in there, and you wouldn't need a bed if the people are living in the motel anyways, as well as restricting it to motel guests.
So not only was it being operated after the 1-year expiration of the special permit, it was being operated in violation of the conditions imposed by the board.
I'm just a little confused on why we're here tonight with this. Because there's been a lot of shuffling and building within this building without permits, is what I'm saying.
Yeah,
I
exactly.
mean, there's no way to turn it around.
So this is a motel, but but there's homes in it?
There's
No,
there's various configurations.
No, you mentioned on these third floor units that are accessed by a spiral staircase and have no windows, and people are living in there?
Correct.
What's
Wait a minute,
happening?
is anybody living in them now? I thought the
entire motel is vacant right now.
Just
That's
the
what I
motel,
thought.
not the
Okay.
other property.
There's a few other apartments throughout the motel. There's one around the pool, which they refer to as the 400 wing. There's one apartment there. There's an apartment on the rear wing, which is the one that kind of runs parallel to...
But it's a motel. It's not an apartment building.
Correct. And they were cited on the change of use from a motel to a multi-unit building as well under the building code.
But there were some people long-term stay. There were people living there, children attending the Middleton school system. So, question whether it was being operated as a motel to begin with when you have a long-term stay. Motel is more transient than it is long-term.
There was people registering to vote as well.
Licenses,
From that address.
Licenses from that address also.
Is that building a Section 8 building?
Our records indicate it's a 54-unit motel.
No Section 8 involved.
Our records, I wouldn't
We wouldn't
know that. Our records indicate it's a 54-unit motel.
So if there were ever a fire and someone was on the third floor up a spiral staircase, the fire department would never have known that.
There was, at one point in the history, there was a fire up there, a small fire that was contained that Chief Martinook might be able to speak to.
But this is what happened, and I think.
Yeah,
I mean,
this-
this is what I can see from this, and I'm just guessing at
I
it.
hate to harp on it, but
Well,
it's life safety
You got a point
issues
there.
here.
You're taking the safety into consideration, which is probably the most important thing out of this whole thing. You had a building that was once used for a certain item, and all of a sudden it's changed within itself magically without permits, so they can inspect something that they don't know about. Again, I don't know why we're here today with this one.
This one-
I'm confused.
Well, and
This
it's
one
blatant
wasn't-
disregard.
yeah.
There was a
This-
special permit for the hydrotherapy tubs when that special permit expired.
it's
They
important-
continued to, maintain the tubs in violation of the permit, didn't bother coming back to the board.
It's important to note that this one was
Sir, would you
inspected.
take your seat, please?
This one was, sorry.
If you're going to be out of order, I'm going to call the police and have him remove you.
Can I speak at a later time?
When the proper time comes, we'll see if it's proper to recognize you. Counsel, we hold you responsible for people you bring in here.
There's a huge safety issue here.
This property,
There's a lot of things
this
going on
property
with this.
was inspected annually by the previous commissioners. It was issued a certificate of inspection for 54 units. That was also subject of that was brought up in the trial. Without sitting down and counting all those rooms, it would be tough to tell that there wasn't 54 without making detailed notes walking through.
And that wasn't part of the inspection was not going in and
Each room,
inspecting
correct.
each.
It's a common area inspection, egresses, lighting.
And would you expect there to be windowless rooms up through spiral staircases and everything if you're doing a common area inspection?
I would.
They didn't know about them.
Yeah, right.
I would- This was inspected, and we had a walkthrough with various people, with the local fire department, the police. The state fire marshal's office was there for the inspection, but Mr. Deacon denied them entry, denied the state building inspector's office entry into the premises at that time. But that was the first time that I had ever seen it, and it was an absolute maze. And I don't know how they'd get the hoses up the stairs and find out where these rooms were, especially in the dark with the power off. And that was the main concern that led to that meeting in April 2014, the rejection of the building permit and the subsequent trial. Because, again, it is a huge safety issue without any sprinklers in that building at all.
But the good thing from a public safety point of view at this point is that nobody's there and they don't have an occupancy. They can't put anybody in there right now, right?
No, because they cannot, the electricity's off. They cannot get the power turned on without a permit, and they cannot get the
Okay.
permit issued absent zoning compliance. So, and that's been vacant since the fire in April of 2014.
Any further discussion?
You cut us off.
Please, I certainly would give you the courtesy of being
Thank
heard,
you.
Counsel.
Thank you so much. Mr. Deacon.
In reference to Mr. Judson Deacon, in reference to the third floor was only used for my employees. And there is a spiral staircase, but it was approved for over 10 years by Mr. Cashman and then all the building inspectors after that. And I also found the plans for the third floor and the second floor, even though they were underwater. And I lost the front page and I lost the back page, which I don't know what's on them. I do have A and B and C's prints. And I want to know why the town hasn't given me a whole copy of my building when I asked them to. Now, I'm going to show the building inspector this, and he can affirm that the stamps are on this, and shows that the third floor and the second floor have multi-units more than 12.
Were these presented in court when you were in court, sir?
No, we couldn't find them. When after we lost the case, we started cleaning up the cellar.
You found these after the
right,
court
and
cases.
they were underwater
Okay.
and had dried out. When I put these through the machine at Staples, the main piece crumbled. It's confetti, but this is what's left of them.
Mr. Deacon, may I ask you a question, please, sir?
Sure.
You have a set of plans for that upstairs.
Yes, it's right
Where's the
there.
building permit that goes with that?
There's a stamp right on it.
No. Is it a building permit stamp, or is it an engineer
Stamped
stamp?
if there wasn't a permit.
Mr. Deacon, these are copies of copies. And these are similar to the plans that I have on file here.
Correct, sir.
See where it says family unit?
Yeah.
And see, these lines aren't parallel that separate the unit, that cut it in half, where you cut them in half, and that line's not parallel. All the other lines drawn are nice and parallel.
Yeah.
So someone at some point has gone in and drawn through those. These very well could have been the stamped plans. These very well could have been the stamped plans that someone has altered and run through a copy machine many times, because ultimately, you were giving the copies of the files.
The stamp is right there.
I
You can
understand.
see it right there.
I understand, Mr. Deacon, but what I'm pointing out to you, these are the same plans I have on file, but if you see the lines drawn by the architect that show the walls are nice and parallel, this here, family unit, this was one unit. These lines are sloppily drawn in, they're not parallel. These were added after the fact, Mr. Deacon.
And look here, another stamp there.
I can't read anything on this, Mr.
Well, it
Deacon.
says
And there's
Town of Middleton.
There's nothing in the
Bill
file.
Cashman. And why don't you have these copies?
It also says office, so this leads me to believe it's your
No,
first,
that's the third floor.
office leads me to believe it's your first floor, but
Now, how come? You haven't got these plans.
So just to be clear, Scott, those are different than the ones that were filed with your office?
yeah, they appear to be the ones that we had in our office at a time.
That is subsequently altered.
They're not all.
Copies of copies. I will note the ones in our file are the original.
I don't know if you can see it.
I don't have to see it.
So they are the
Building commissioner
originals
has
with
to
the
see it.
stamp,
He's
no,
the-
no, not those,
he's
but
the
in
authority.
your office
So
with
do
the
we
raised
want to
stamp
take
from the
those in?
architect, or?
We have the originals.
us
Those
to
are
admit, I think he
copies of
kills them,
copies
but-
of copies which appeared to be altered.
That's up to him.
So, Mr. Deacon, are you offering those into evidence today?
What's that, ma'am? What's that?
Your attorney answered the question.
I didn't hear him.
I asked if you were offering those into evidence today.
The council said no. Is that-
Well, we asked him.
I told you that it has to be submitted a week ahead of time, but we extended the courtesy to you to allow you to show them. Okay?
Thank you, sir.
You're welcome.
We went to court, and they found me not guilty. They dismissed all the cases against me on the violations of the spiral staircases and and the rooms.
Are you all set, counsel?
Individual who'd like to speak to you.
As far as the statement of 54 units...
Excuse
in
me,
the-
sir, would you identify
Oh, I'm
yourself
sorry,
for the
Phil-
record?
Phil Crotty, I apologize. As far as the statement that there were only 54 units on anything in the town, the night of the fire, the police report states 64 units. The fire department report states 64 units. The assessor's office has 64 units. Your own map showing the plot and everything else of that building shows 64 units. So I don't know where they're coming up with these 54 units. Do they have a stamped permit that actually says 54 units?
I can answer that, Mr. Crotty. We have zoning approvals for 54,
And only 54.
and that was
Then
the...
why is everybody else in town noted 64, including the assessor's office?
That's what they counted.
Once again, the assessors count what you have and tax what you have. If you
64.
If you're familiar with zoning, Mr. Crotty, assessors do not set legal use. The building department does. 54 units.
Why does everybody have 64 units, though?
Except the only person that matters, which is the building commissioner's file.
And
Has
where does the
54.
assessor get the number of units from?
They count them.
So they counted 64.
They must have.
And you were permitted
So
for 54.
I counted.
30 some odd years, we've been billed for 64 units, and now all of a sudden they're no good.
Right. Exactly. Doesn't make it
Because
right.
you only got permission
I don't
from
know
this
why we're
board
here
for
then.
54 units.
I don't know why you're here either, Mr. Crotty.
Have a good night.
There being no further discussion, I will make a motion.
Please do so.
I move that the board vote to affirm the order of the building commissioner in this appeal of his decision. I incorporate into my motion Town of Middleton letter referencing 319 North Main Street, Middleton, dated October 13th, 2016. We heard testimony tonight from the applicant, his attorney, the building commissioner, and town council. In addition, we have reviewed the documentation presented by the applicant council, as well as reviewed a Superior Court decision concerning the premises that are the subject of the matter in appeal before us tonight. And this decision questions the credibility of the applicant's testimony about why he may disregard the ZBA's restrictions, as well as struck down arguments advanced by his counsel as to why he did not have to comply with zoning requirements on these premises. Based on the testimony and evidence presented, it is clear that the applicant has failed to demonstrate any reason why said order of the building commissioner should be reversed by this board. It is also clear that there are numerous violations of the Milton zoning bylaw and state building code, as noted in the building commissioner's order. Based upon the foregoing, I move that we affirm this order. Is there a second? Second.
Yep.
All those in favor?
Yep.
Yes.
Yes.
Vote is unanimous. The request is denied. Next item on the agenda is application 1025, reference 11 Rockaway Road. Is there anyone here to speak in favor?
Be pertinent, my name is Loring Fluke. I appear for Judson I. Deacon. You have before you an affidavit of Judson I. Deacon trustee. Pertinent portion of the affidavit indicates that Mr. Deacon purchased the property on or about June 1 of 1976. Since 1980, the property has been used for the rental of units and has always been so. The premises contain fire doors, fire alarms, CO2 detectors, emergency lights, and fire extinguishers. During the years that Mr. Deacon has owned the property, it's been inspected on multiple occasions by the then-serving building commissioner of the town of Middleton, as well as other officials. And with minor exceptions not relevant to these proceedings, the property has always passed inspection. To Mr. Deacon's knowledge, the property has never been a single-family residence, and the fact that it contains 3 floors and 16 rooms belies the town's suggestion that the property was designed, built, and used as a single-family residence. Thank you.
Anyone else to speak in favor of the application? Anyone to speak against the application? Commissioner?
Once again, the property was inspected as a result of the counterclaim of the civil action in Essex Superior Court. Myself, Chief Martinook, and Lieutenant Kessel inspected the property. The first floor of the structure had a function room, place of assembly, commercial kitchen, commercial-style bathrooms. The basement had 5 or 6 partially constructed rooms, various stages of construction, some drywall on the walls, some studding, and electrical wires with the dates of 3/16/2002. There are no permits on file for any of that work. The second floor, there was multiple units of various configurations, 1-bedrooms, studios, and motel-style units. The third floor also contained a variation of motel-style units, studios, and 1-bedroom apartments. After the inspection, A review of our records indicate the structure is a single-family dwelling with the building permit issued on April 26th of 1989. Permit was renewed on November 12th of 1991, and a subsequent occupancy permit was issued on November 13th of 1991. There are no other permits or occupancies to change the use of the structure to a multifamily dwelling. There are also no record of any 110 inspections. There's also a half-constructed addition on the right side of the structure, which is weather-tight, open and exposed framing on the inside of the building.
Thank you, Commissioner. Anyone else to speak in opposition? Any discussion from the board?
Scott, can you clarify the garage? Are there residential units on the second floor of the garage?
Yes.
Okay,
Yeah.
that was my understanding of your order to them, because you talk about a second floor with finished rooms, and then you order them.
We're on 11.
What?
I think you're thinking of 8. We're on 11. 11 does have a garage in the rear
Okay,
at the main level, and the second floor extends over it.
okay, all right. So, wait a minute, I'm getting
Yeah.
myself confused on all
Yeah,
these.
you're thinking of 8.
I'm one ahead of myself. So is there a garage on this one?
There is. There's a large garage at the first floor at the rear of the building.
And there's residential in this garage as well?
The garage is attached. It's at the end of the building. At the
Okay,
end of the first floor at the main level, and then the second and third floor extend over the garage.
Does it all meet code
So was
today?
it built fireproof? Then we don't
We don't
know.
It wasn't, I can't speak to that as I didn't do, construction inspections
So
there.
this assembly room, what is that?
There's a large, what the chief and I have referred to as a function room on the
With a
first.
professional kitchen.
On the other side, there's a commercial kitchen, large commercial stove with no hood on it. And I will add that after the cease and desist was issued, the Middleton Fire Department responded to a medical aid, at which point the chief was able to enter the property, and the room was being used.
As what?
There was a gathering going on. The chief can speak more to that as he entered the property.
In no hood over the
Correct.
appliances.
And no fire suppression system over the stove, which
I-
I
You don't have a hood, you don't
imagine
have
you
a fire
have to have.
I just,
suppression.
the chief's here, he's been sitting there patiently. I don't know if he has anything to add to any of this.
Chief? Chief Butler?
We were wondering if you had anything, I said, I don't know if you had anything to add to anything. I'm curious, I don't know if any of the board members are, but you've been sitting there so patiently, and we keep talking about you.
No, we just talk about the medical aid we had up there. Let me come from. Cindy was just asking me where it was. We had gone up there, Scott, 3 weeks ago? Tom Martinook, 17 Park Ave, Fire Chief. We had gone up there about 3 weeks ago for medical aid in that unit, and they were having a small gathering after a funeral, I believe it was, and there was about 15, 20 people in there. That's what it was.
Chief, the commissioner told us over the appliances there was no hoods or suppression system.
The appliances, from the looks of them, they haven't been used in years, but they're commercial units, and I don't know when the last time they were used, but they were there.
Well, commercial units require all kinds of fire
Tell me about it.
rating walls around, and
Mr. Abbott knows better than I.
yeah.
But in general on this property, do you have any other concerns?
We're talking about Gingerville, right? Correct.
Yeah.
Yes, it's a huge building. It's not sprinkled. It does have an older fire alarm system in it, but there are people living there, and just the bottom line here, like I was telling these other people, we're just looking to make these places safe. And, safe, yes. Safe for the people who live in. We're not here to, like Scott had talked to Mr. Deacon, we're here to make the place safe for everyone. Bottom line.
Thank you, Chief. Is there any further discussion? There being no further discussion, I'll make a motion. I move that the board vote to affirm the order of the building commissioner in this appeal of his decision. I incorporated into my motion the letter from the Town of Middleton Building Department, reference 11 Rockaway Road in Middleton, dated October 11th, 2016. We've heard testimony tonight from the applicant, his attorney, the building commissioner, the town council. In addition, we have reviewed documentation presented by the applicant's counsel, as well as reviewed a Superior Court decision concerning the premises that are the subject of the matter and the appeals before us tonight. And this decision questions the credibility of the applicant's testimony about why he may disregard the ZBA's restrictions, as well as struck down arguments advanced by his counsel as to why he did not comply with the zoning requirements of the premises. Based on the testimony and evidence presented, it is clear that the applicant has failed to demonstrate any reason why said order of the building commissioner should be reversed by this board. It is also clear that there are numerous violations of the Middleton zoning bylaws and state building code. As noted in the building commissioner's order, based upon the foregoing, I move to affirm the order. Is there a second?
Second.
Motion is made and second. All those in favor?
Yes.
Yep.
Yes.
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 Yes. And I vote yes. The application is denied.
Next one.
Next item is 2010-26.
1026, you got it.
And
8 Rockaway
this
Road.
is 8 Rockaway.
Yep.
Next application on the agenda is application 1026, reference 8 Rockaway Road in Middleton. Is there anyone present to speak in favor of the application?
Is that 8 Rockaway or 6 Rockaway?
8 Rockaway.
8 Rockaway, application 1026, Council.
1026.
Correct.
1026.
My name is Loring Fluke. I appear for Judson Deacon in regard to the property at 8 Rockaway Road in Middleton. We have filed an affidavit on behalf of Mr. Deacon, which you have before you. The pertinent portions of this particular affidavit indicates that he purchased the property on or about July 1 of 1982. In addition to that, he purchased the property, and since at all times this property has been used as an 8-unit multifamily residential dwelling and has always been used as such. The garage is not being used, it's never been used as a residence, and a careful reading of the building commissioner's order reveals no such allegations. During the year that he's owned the property, it's been inspected on multiple occasions by the then building commissioner of the town of Middleton, as well as other local officials, and with minor exceptions not relevant to these proceedings. To Mr. Deacon's knowledge, the property has never been a single-family residence, and the fact that it contains 3 floors comprised of 4 units on the first floor, 3 units on the second floor, and 2 units on the third floor belies the town's suggestion that the property was designed, built, and used as a single-family residence. This has been inspected on numerous occasions. Thank you.
Is there anyone else to speak in favor of the application?
I live at 8 Rockaway Road. Judson Deacon. I live at 8 Rockaway Road. The building inspector knew the history of this building when it had a fire in it. It also, when we built it, the architect drew him plans. He gave him the plans. We filed a building permit with it. I don't know what it said, but whatever it said, it complied with whatever there was there. I had documents here that I can't present to you that show an affidavit for people who had lived there, including the building inspector himself told me that one of his cousins lived there. This is 35 years ago or 32 years ago. I really don't know. Thank you very much.
Thank you, sir. Is there anyone here to speak in opposition to the application? Commissioner?
Once again, the property was inspected by myself, Lieutenant Kessel, Chief Motnook, as a result of the counterclaim and the civil action in Essex Superior Court. We inspected the property. The first floor contains 4 motel units. Bedroom, bathroom, separate room with whirlpool tub, furnished with a bed, TV, bureau, right down to the checkout time, a little plaque hanging on the door casing that tells the checkout time and where to leave the key. Second floor, the right-hand side, we were unable to access that unit. We were told that was Mr. Deacon's unit. He wasn't home at the time. We were told that's a 1-bedroom apartment. Second floor, left-hand side, there's 2 studio apartments. One of those studio apartments is only served by one means of egress and was cited under the dangerous and unsafe section of the State Building Code. The third floor contained 2 one-bedroom apartments. There's a garage that was constructed at the rear of the property. Permits were issued to construct the garage for storage. The garage, first floor was your standard garage bay. The second floor was finished with, I believe, 5 rooms. Permit was issued for a storage garage with the second floor for storage. These rooms were finished with drywall, closets, finished flooring. They were not occupied at the time of the inspection. As far as the structure, our records indicate it was rebuilt as a single-family dwelling.
Scott, when? Do you know when that was?
I don't have the date, no, on that one.
Why were all these houses rebuilt? Were they all, did they burn down?
This
or-
one, I believe, was fire damaged as well. I think Mr. Deacon just,
Did they all have fires? Did
I'm not,
a
Mr.
couple
Deacon
of them
can,
have fires? Did a number of these properties have fires?
Yes, that's why I bought them.
All in that area?
Yep. They were small fires.
once again, there's no 110 inspections on file, these multi-unit buildings. This building is served by the second means of egress for the units that have them on the second and third floor, served by a spiral staircase, which is not allowed, and hasn't been allowed in the state building code for anything above a two-family dwelling.
So is there a building permit for, where are we now, 8 Rockaway as a single-family dwelling?
I don't have a date listed.
But is there a building permit in the file?
I'm not sure. Have to check that one.
But there was an occupancy permit.
It says our records indicate it was rebuilt as a single family, which leads me to believe there's a building permit, but
Right.
no
Right.
occupancy, because I didn't refer to the occupancy in
Okay.
the order.
So how does that work? Well, they got an occupancy permit for the
Garage as storage, and
just for storage,
they were allowed to rebuild as a single family dwelling.
post-fire.
Correct. Once again, this one's being used as a mixed use, motel rooms, studio apartments, and one-bedroom apartments.
And these whirlpool tubs are different than the hydrotherapy tubs?
Yeah, the first floor motel-style units have a bathroom, then they have a separate room in the motel that has a whirlpool-style tub of various shapes. And I will add, Mr. Deacon was well aware of the zoning process to add units at the property, because it should go through the file for 319, the motel. Mr. Deacon and his attorney were in front of the board many times as he expanded the property from its original configuration as a one-story motel, 3 or 4 times, I believe, to add the various units in the pool. So they're no stranger to the process to add to the buildings, convert the units.
So the hotel is closed,
Correct.
but is there still a motel function going on?
The rooms we identified as motel-style rooms were not occupied at the time of inspection. The second and third floor were occupied at the time of inspection. Not sure if that's how it stands today.
There's 5 different buildings on this property.
Yeah. And this one was partially occupied.
Thank you, Commissioner. Anyone else to speak in opposition to the application? If not, any discussion from the board? Being no further discussion, I'll file a motion. I move that the board vote to affirm the order of the building commissioner in this appeal of his decision. And I incorporate into my motion a letter from the Town of Middleton Building Department dated October 11th, 2016, reference 8 Rockaway Road, Middleton. We've heard testimony tonight from the applicant, his attorney, the building commissioner, and town council. In addition, we have reviewed documentation presented by the applicant's counsel, as well as reviewed a Superior Court decision concerning the premises that are the subject of the matter in the appeals before us tonight. This decision questions the credibility of the applicant's testimony about why he may disregard the ZBA's restrictions, as well as struck down the arguments advanced by his counsel as to why he did not have to comply with the zoning requirements on these premises. Based upon the testimony and evidence presented, it is clear that the applicant has failed to demonstrate any reason why said order of the building commissioner should be reversed by this board. It is also clear that there are numerous violations of the Middleton zoning bylaws and state building code, as noted by the building commissioner's order. Based upon the foregoing, I move that we affirm this order. Is there a second?
Second. Second.
Motion's made and second. All those in favor?
Aye.
Yes.
Aye.
Yes.
Motion is unanimous. The appeal is denied.
Before, can I just check with Michelle? I know we got a little confused with some of the numbers on some of the appeals. Let's just make sure that Michelle has everything down.
That I would recommend that you redo the
the
motion
minutes.
on is for
329.
329 North Main Street. When you made the motion for application 1023, you stated street address 319 opposed to 329. So there was no official vote for 329 North Main. So I would redo that motion.
It should be 329.
319 though.
Yeah,
When you
that was
made-
an error.
Yeah. So
You corrected?
I corrected it. I just wanted to make
Yep.
sure that it didn't affect your vote.
That's correct. 329 should be.
Well, I think, just for the record, we should rescind the vote, and
Or you could just go through the whole agenda and,
what do you think? Go through and read?
yeah. If I may,
You want us just to go through them each and affirm the commissioner's order on each of these?
right. Or just, if I can make the motion, and you could just say so moved.
Since when can you make a motion?
No,
You want to be on the board? That would be
No,
great.
I don't. No, I then you say so moved.
I will give you my spot.
That someone make a motion that when you voted to affirm the building commissioner's decision on application 1022,
1023.
that referenced 6 Rockaway Road,
Oh, I see what you mean. Yep.
and
Yeah.
Okay, go all the way
I see what you mean. You follow?
It's 1023,
verify.
correct?
well, no,
Yep.
you,
What he's stating
Sure.
is he
You have to go
wants-
through each
Go through the whole
Compound wants you to
agenda.
go
Go
through
through the
all
whole
of the-
one.
Just read each one. So 122 is number 6.
Okay, so the first is.
Do you want them all in order?
I got them right here.
You do? Okay. Oh, there you go. Okay. Yeah, just read them through.
24, 25, and
Okay, just to affirm the motion, we'll start with A's 6 Rockaway Road, application 1022, 329 North Main Street, application 1023, 319 North Main Street, application 1024, 11 Rockaway Road, application 1025, 8 Rockaway Road, application 1026.
Very good.
You're moving to confirm that the
We're moving to confirm. Is there a
that the
second?
commissioner's order was affirmed on each of those. So moved. Right. Second.
All those in favor?
Yes.
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 Unanimous. Next item on the agenda, application 1021, 17 Old Essex Street in Middleton. Is there anyone here to speak in favor?
Good evening, Jill Mann, and Mann, legal counsel to J.J. McCarthy, LLC, the applicant in connection with a common driveway permit. Here with me this evening is John McCarthy, the principal of that particular developer. This particular application we opened on, November 17th, and we have presented to you the common driveway plan. Since that time, we have had, I'm going to give you just an updated plan because we added a water line earlier. So basically, we did appear before the planning board. We did appear before the conservation commission. We have had conversations with Chief Martinock, who's down there in the back, regarding this particular person. And we do, by the way, have our walk with Concom tomorrow. I apologize, on Saturday. The desire of this evening's meeting is to be able to get a final determination from this board so that we can present the Conservation Commission with a final driveway plan, if you will. So what you see in front of you today is exactly what we had before. The only difference is we modified the turnaround because we had discussions with Chief Martinock, and we actually added 2 fire hydrants because we are bringing the water line down from Essex Street, up Old Essex, and to this particular property, so we'll actually bring water to this area. In addition, the added benefit of Mr. McCarthy bringing water is that we will actually have a hydrant now on Old Essex, which never was the case. The reason we're seeking the common driveway is because if we do not, we will have 2 300-and-something foot driveways. This area does have wetlands which abut the property and are on the old plan that you did have. And then if you turn to the second page, I can go through it a little more too. But in order to not have both lots accessed by these very long driveways, we're proposing the common driveway. This is actually a very similar situation to that common driveway that this board had approved in 2014. I call it the Maidman property. It's the property Olson Way. It was one of the properties off of East Street, and it too was a 4-lot subdivision. This particular driveway complies with all of the requirements of the zoning bylaw. In addition to that, in addition to Chief Martinock being here, I do have actually, I didn't print out, I didn't know if you had copies as well, but do you mind if you share? Sure, it's okay. Excuse me. I'll give you guys one more. Okay. And then so that's from Chief Martinock, just basically confirming, and you obviously can speak with him this evening, his belief that the common driveway actually is satisfactory. In addition, I gave to you a summary, or if you will, an opinion statement by Mr. Lavoisier saying that he too has reviewed the common driveway and that it does in fact comply with the requirements. This particular driveway is a 12-foot wide driveway. It is built on the side of the sloping terrain. When we had done our site walk on November 19th, we had shown you where this driveway went up, and it was very easy to show you because if you look on the second page of the plans that I presented to you, that is one of the areas where we have a path that was going up the hill, up the side of the hill. And one of the reasons we located the driveway in the particular area was because we were able to take advantage of where the path already existed and to have to just cut into this one area instead of on the other side as well, because where we would put the driveway for the other home would have been actually in between where the development is, or if you will, the improvements are for the home and then the existing hill. So it would have been cutting into more topography. The driveway does have a turnaround, as I said, that is sufficient to allow any of the Middleton fire apparatus to turn. In addition to that, as I said, we do have a hydrant located at the split. So when we had originally got the first, if you will, common driveway approved, we were requested by Chief Twist, Chief Martin's predecessor, to put in signage that basically said, listen, this is, unit 319 or whatever the units are, I'm making it up. But those numbers will be given to us by Mr. Fitzpatrick, and then we'll put them as well as signage so that people know, or in particular public safety officials, know which way the homes are, because it is a common driveway. The driveway will be graveled with bituminous over it. The requirements under 6.3.6 require that there be no greater than a 6% slope. The slope is under, it's about maybe 5 1/4, 5 1/3%, so it's under the 6% slope. It also requires that the road take a turn of greater than 45. We have an 85-degree turn, so it's safe from the existing access way. We did present to this board with the application that was presented a common driveway easement agreement, which is part of the requirement, so that this board understands that those driveways, everybody knows who owns them, is going to have a common maintenance obligation. It's kind of unusual in this particular circumstance because the roadway we're actually going to put in, we're going to make it all one big subdivision. So, I apologize, one big condominium. The reason for that is the whole subdivision will be a condominium. Each lot will be a unit, and all areas basically get maintained by the condominium. You might ask why? Because homeowner associations don't work in Massachusetts, because there's no statutory imposition of the ability to, if you will, lien property when they don't pay. So by making it a condominium, I have the right to lien if John tells me somebody didn't pay to, plow the roadway. That's the beauty of a condo. And it's just a simple style of ownership. And basically, that's it for the condominium, for the common drive. I don't know if the board might have questions.
What did the planning board do?
Nothing. They don't talk about the common drive. It's all you.
No,
So-
in general. They
Sure.
went on the site walk with us.
Yeah.
I'm curious as to what they're doing with this.
Nothing yet. We still have, okay, so it got referred to the planning board, and Mr. Lavoisier sent out the stormwater to our new third-party engineer, Linden Engineering. They have yet to come back with any comments because it's brand new, so Mr. Lavoisier said it's going to take them a little more time because it's the first time they've reviewed. So we simply continue.
You've known me a long time.
Yeah. I know, but you know what the problem is?
You know where I'm coming from on this.
I
We don't know
absolutely do.
what planning, let me talk, Attorney Mann. We don't know what planning board's going to do. We don't know what Concom's going to do. And I am very leery about approving anything in the abstract, not knowing how this design is going to change, how the site plan could change. And somewhere I read something that things could shift. And if things shift, the common driveway could shift.
I can address that. So first,
I'm sure you can.
Yeah.
But I'm telling you, I, for one, am not interested in voting on this tonight.
I think those
Not knowing what, especially where Concom is coming from. And I went on the site walk. I think it's a beautiful location. The views are spectacular.
It's a beautiful property.
But it's in the middle of wetlands.
But this
and
is
I want to know what the Concom says.
You have to understand. I'm asking for your decision tonight because I need to be able to tell the Concom if you want a 12-foot driveway, if you want a 14-foot driveway. They can't approve until you approve. They're the real determinant. This is accurate. I am not making it up. The board in the Conservation Commission can't say that the common driveway is okay if they can't put the common driveway in. They don't know how wide you want the common driveway. They don't know if you think the location of the common driveway is okay. If this board chooses not to approve the common driveway, then I'm going to put 2 in the Conservation Commission has to approve it. If this board doesn't decide, then you force me to go to the Conservation Commission and then come back here again. You want to talk about a waste of your time. That is just...
We're here anyway, Attorney.
But that's not the point. It's a judicial waste of time when you create additional meetings. The point here is you are not... When you say granting permits in the abstract, I'm not asking you for a use permit. I'm saying to you, I would like for you to approve this common driveway so that I can actually show it to the Conservation Commission. As far as the planning board goes, they have nothing to do with this. Nothing. Common driveways, all I have to do is show lots. I don't have to show driveways on, and Mr. Fitzpatrick can attest to this. I don't have to show driveways on subdivision plans. I don't have to show anything other than the fact that my lot complies. What I'm simply trying to do...
haven't they approved it?
Who? I just finished telling you why, because the third-party engineer hasn't responded because it's the first time it's reviewed the storm.
What if he has something to say about it?
I mean, hasn't it gone to them
Again, they don't say, they have no jurisdiction to say anything about the common driveway permit, which is why, quite frankly, the way the bylaw's written, it was inappropriate to have this board make that decision. It should have been with planning so that it would have been part of their process. Instead, it's a very odd process. It's now...
I'm not saying be that as it may, we have a lot of odd processes.
We do. So it would have been easier to simply, I shouldn't even say easier, it would have made much more sense to have this rest with the planning board, but I understand it didn't. For some reason, whoever drafted it didn't really think about who the special permitting authority should be, so it is you. But if you don't make your decision, the Conservation Commission cannot finalize its plan. What is it even looking at? You're not telling it if it can have a common driveway. And by the way, if they don't like the common driveway...
They're looking at your proposal,
Again,
Jill.
you are wrong. The proposal doesn't count until you approve the common driveway. They can't. What are they approving? If they say to me, Jill, is the 12-foot okay? Okay, we're going to approve this because they approved a 12-foot wide common driveway. Okay. Now, I come back to you, right? And you go, no, we want 14. Now I've already got an issue.
Why don't you have a discussion with this board while they're all here and ask them how wide they think
if
the
you are going to
driveway
vote on
should
that,
be.
then vote on it. My point is this board is trying to force a decision that's inappropriate. That is inappropriate to require that the Conservation Commission approve it. I have a question for you. This is even better. What do you think a permit for a common driveway for a project would actually provide me? Absolutely nothing other than a beautiful roadmap with which to say to the Conservation Commission, here's the location, do you like it? And if they don't like it, then we can't do it. But
Well, what if they say we might like it better over here or over here?
Again,
Excuse me for a minute, Jill.
If we relocate it slightly, quite frankly, it doesn't really have too much of an impact. You're approving whether or not it complies with the 12 feet and all of the other standards. A shift, this is not a structure. The only reason you even approve it is to make sure it's safe.
But Jill, you do this all the time. You
Right,
come
and-
to us, and you want things done so quickly, and sometimes I feel like we don't, or you know what, I can just speak for myself. I wish sometimes I had more information.
What
It would make
information
me
would you like? This is the
feel
second
more
meeting
this
we've been before you.
happened last, and Concom was supposed to have their site walk done.
No, they were not. You're incorrect. I said to you we had a meeting and they were going to have their site walk announced. You are totally wrong. We had our meeting on November 19th. I told you I had my hearing on December 2nd. They were going to approve. They
You
were
were
going to set up
hoping
their
that
site
we would
walk.
all go together.
And I asked them to do that, and I emailed, which I know you don't believe, but you can ask anybody. You said that before to me. I actually did ask Kristen. I sent it to her. She said nobody was able. Oh, Mr. Sliney's here. Nobody was able to actually make. That's right. Look at Mr. Sliney's here from the Conservation Commission. I didn't even think of that. So, Mr. Sliney, we asked them to go. The Conservation Commission couldn't make the 19th. They were able to make, and they accelerated. They said, okay, we'll go. They tried to make it the week before. Nobody could do it, so we're doing it this coming weekend on Saturday.
Attorney Baird, I have a question.
Mr. Yeba.
And how do we know you're not making it up? But no, I'm only kidding.
You know what? You don't.
I got a question. If we approve something tonight,
Yeah.
the driveway, and it goes to conservation, I've been up since 6 o'clock, so I'm a little tired. But if we go to goes to conservation, and if for some reason they don't like the way something's working, you got to come back to us?
I don't have a choice.
You don't have a choice to come back to us.
If they actually
You
don't
have to come
like
back
something,
to us. So if they like, if we were to approve it, and they don't like it for whatever reason, you got to come back here anyway. Is that correct or incorrect?
Not if we've issued a decision.
It would depend, like, for example, if I said to you, look, if the Conservation Commission made me move it 2 feet away from the wetland, because, okay, I'll give you an example. If you look at your plan right now, if the plan you see right before you, it's a 12-foot wide way. In the past, you've made me go to 14. I'm asking for 12 feet because I think it's in the best interest of the particular surrounding, and I think that it's in the best interest of the Conservation Commission, given the types of property and the hill on one side. So if you allow us to do the 12...
Excuse me, can I just say, this is because you didn't want to cut into the hill, if I recall. Was that part of it?
Right, because nobody wants to take down that hill. That's why the other driveway, if I would have to do 2, I have to plow down the hill. That wouldn't be the prettiest thing in the world. It doesn't, for conservation purposes, it's not recommended or desired. So this one, and I'm not saying, by the way, they like where we're going either. I'm not telling you that they're happy that we're not giving them, more space. But our current plan does give them more than they had seen before. So at the present time, I have a 12-foot wide driveway. If the board said to me, Jill, we need 14 feet, I have the ability to make it 14 feet and push it out into that. If you look on your plan before you, and you're looking down, I have the ability to make that road 2 feet wider. Okay? If you tell me you don't want it 2 feet wider, then I'm taking that probably, and I'm going to tell you tonight, I'm picking it up and I'm going to slide it 2 feet over, because if I can get it further away from the wetlands for the Conservation Commission, I'm going to do it. So if you want 14 feet, that's why I'm here. If you want 14 feet, I can't give them the additional 2 feet of shift because it causes a ledge. What I would have to do would be a ledge cut in, destabilize the hill, and it would really create not an attractive approach at all, nor would it be great for the hill. So that's why. I understand the board's position. Jill, we would like everything in a nice package. I do understand. It's just that, unfortunately, our process, our timing, our board meetings don't permit us to do things in that great an order. We don't.
Then let's fix the process.
I have tried it 14 times to fix the process. I can't get any board to agree to meet more than once a month, and sometimes I can't get
That's
that.
not fair, because we've had many special meetings,
You do.
too.
You are great about it. I'm not saying just you. Every board in town, it's once a month, and you know it can be tough. But, so the point is I simply am trying to get a decision so that I can go to the board, so I would love to be able to give, because it's my money, right, that I'm spending, poor Mr. McCarthy. I would love to be able to have that road shift 2 feet over. If you tell me you want 14 feet, then we're gonna give you 14 feet, we're gonna amend the plan, and I'm not shifting the road.
What's legal, 12 or 14? So why are we talking about 14?
Because, as I said before, in one other of my applications, you asked me to make it 14 for some reason.
What was Olson?
You made that one 14. Colosi, I believe, was 12. Was it 12?
So we got wetlands here. Are we okay with 12?
But why did we do 14 in Olson?
I have no idea. The bylaw provides for 12. I honestly can't answer that, Ms. Pacelli.
Yeah, I can't remember either.
I mean, if I may, Chief Martin up this year, he said that your fire apparatus, because we have a...
Don't ask me this question.
Okay, don't ask me.
I tell you to put 20 feet.
Yeah, he wants 20 feet for the...
Now you've already approved
We do have a...
Well, that doesn't help you, Bill.
No, our roadway...
Hey, Tom, we're going to make it 60 feet for you.
Our roadway, when we originally did it, was 18 feet, the subdivision roadway, and we broadened it to 20 feet because Chief Martinook says you cannot have a public street that's under 18 feet. So we made that 20. This particular driveway is 12, and we made sure that the turnaround at the top was big enough so that his apparatus could turn. And we were asked to not to... Chief Martinook strongly suggested that Mr. McCarthy consider bringing water to the site so that he did not have to bring tankers in, so that he would be able to just come in and attach to a hydrant versus attach a tanker? You attach a tanker?
The driveway, the way it is, it would block up the driveway of the tank.
So that was the point. So we did that. And we have 2 hydrants, though. One in the subdivision and then one up the top. I apologize, Mr. Mazzaro.
Are you finished?
That's why I said I apologize. I kept seeing you wanted it, and I'm like, keep going.
Kind of getting to the repetitive stage.
Go
so,
for it.
I'd be interested in hearing the chief's position. Do you have an opinion, Chief, as to whether this should be 12 or 14 feet? I know that it's
We're talking
hardship
about
on the engines getting up there.
Or maybe 13.
The road coming into the cul-de-sac is a normal town road, 20 feet with a cul-de-sac that fits our apparatus. What Joe said is this common driveway, they made 12 feet, which is wide enough for us, and they brought the water down, which is a huge help for us. And they also made it so our apparatus can turn around at the end, so I'm happy with it.
You don't have a difference between 12 or 14? Doesn't make any difference to you?
I mean, if 14 would be better, but 12 is adequate. I mean, if it affects the wetlands and, whatnot. 12 is good.
Well, the wetland is a definite consideration here in putting the
So
road in.
12 is
That's
adequate.
why-
If they can go 14 without too much trouble.
That's
even
why our
better,
board
but-
is concerned about Comcast and
Concom.
Concom, excuse me. And,
So 12 is
if we make a decision and then somebody over there says, well, the wetland, we determine the wetland by this little plant here that's grown over here, and it's within such a distance of the road
12,
that
originally
it's illegal. and-
Originally, it was 10. They went to 12, and they made the turnaround for us at the end and brought the water down. I'm very happy with that. They were great to work with. So.
Thank you.
Thank you.
Thanks. Thank you, Chief.
I think the main concern, Council, of the board is that we don't have a complete package, and as we usually do.
Of course you do.
Well, the
Information-wise, yeah.
Well, that's
is
not,
not complete.
I'll be honest
And
with
I've
you.
seen some of these things where we determine the wetland starts here, and it's too close to the road, and
We
you're
have a
asking us to
wetland
make an approval before they
Oh, no.
determine where the wetland really starts and ends.
We have we have a wetland line that has been confirmed by the agent. If I may, can you just confirm that, Mike? Oh, not that we have an NOI, but we have Kristen confirmed the line?
Yes, he has.
Mr. Sliney sits on the board. Mike Sliney from the
You have a
Conservation
definite
Commission.
line.
Oh, yeah, the wetland line has been confirmed, identified, we have it.
Maybe they could approve it in
Council,
recognition of Concom.
Council, please, if he's going to address the board, would you ask him if he'd stand up and identify himself?
He's a member of the
I
Conservation
understand
Commission.
that.
You need to
If
ask
he's going to
him.
stand there and talk to you in front of us, we'd prefer that he tell the board what he's going to say. If it's important enough to discuss with you, it certainly is important enough to share with us.
I don't disagree. I think you should ask him to speak.
Sir, would you like to address the board?
Yes, okay.
Thank you.
My name is Mike Slaney. I'm on Concom. I'm not here for this, but anyway, what she says is accurate, and maybe you can make a decision on what the Concom decides. You approve of it if the Concom agrees with it. If they don't agree with it, then your approval might not work. Something like that.
If it doesn't work, she's coming back, is that it?
That's right.
Well, yeah, I mean, again, if it doesn't, we just need something definitive to go forward.
She's got a line. She's got a line. She's got the 12 feet. She's got the chief's thumb up. He wants 50 feet if he can get it. They all want more. I go through that with you all the time. All right? But if you've got all the pieces to it,
No, I know, but even, it is a driveway, and if the fire chief is okay with it, I am in agreement that I would prefer to have a smaller roadway through, a beautiful natural setting, than an extra 2 feet that really isn't required. I agree not to mess with the roadway, obviously, but if it's a driveway,
I mean, that's how I feel about it. Dick. I mean, I think we're kicking a dead horse on this one.
Have you completed your presentation?
I'm absolutely just standing here waiting for questions, Mr. Nazaro.
There being no questions, is there anyone here to speak in opposition to the application? There being nobody here to speak in opposition, does the board have any further discussion?
I'm not opposed to a common driveway. I mean, I agree with what Ian said, that, again, because I went on the sidewalk and it's beautiful. And you do want to limit the
The space, yeah, the driveway, yeah.
the driveway and the pavement and all that stuff through there. I'm just reluctant to approve it now, not knowing about Concom.
And I would ask the board to approve it, subject to, you can make a condition, because, again, you don't give me anything.
We give you things all the time.
But I apologize. So this is a special permit?
And we're not sure she's making this all up, you
If
know
I
that?
don't get conservation.
I never said that.
No, but I mean, if I can't get, I didn't hear that, Mr. Yapa.
He said, we're not sure you're not making it all up.
No, I mean, my point is if you're granting a special permit because you need to make sure that we comply with all the requirements. The requirements do not involve getting Conservation Commission approval. You're not even, it's nothing in the regulations that even require that. But it is something in their regulations that I have to show them that I actually have the ability, because I have to prove alternatives analysis, I have to go in and say what the burdens are, I have to show the difference, and I have to say, look, this is what the Board of Appeals has approved. If the Board of Appeals approves something bigger, that's what I would have to go with. And that's why we need your approval. Say it's subject to their approvals. It is anyway.
You can tell them
Again,
that
I have to
the
tell you,
board...
this is just so, I can't make anybody make any kind of decisions, but I have to tell you that your regulations do not permit you to have an extraneous an extraneous requirement for board approval at another meeting. The board is supposed to evaluate pursuant to the regulations as they are in place, and that simply means looking at the plan we presented you and telling us if we comply with the requirements. That's literally what 6.3.6. And I'm telling you that if you want to condition it, please do. I have no problem with that.
But are we...
You know, you're always in a hurry, Jill, and that's part of the problem.
It would be 120 days if I wait for the next meeting. 120. That's a long
How's
time.
it
That's
120 days? It's next month.
120 days. We applied in October.
120 days.
You were here before us in November. We did a site walk within 2 days of the meeting.
I'm not telling you you aren't wonderful about doing that. It's just your meeting times are not, again, you aren't approving anything. You're not approving the use of the building. You're not approving me going forward and doing anything. It's simply allowing me to go to another board with an approval and not have to come back again if that is really what they're willing to do. You get it.
Said I get it. I get it.
So make a motion then.
I'll make a motion that we approve the common driveway at the width of 12 feet with on a condition that it's approved by
Did you do a draft? None of us got it.
I sent it out to Lisa, and I sent it to Katrina, never did anything about it. Okay. I sent it.
Katrina, I think, had a day off today. I don't
She
see.
emailed me a couple of times. I apologize. No, she told me it was. I apologize. Yes,
Oh, I got
did.
that.
Oh, you did. Okay.
Yeah. But I don't think the board got it.
I'm not allowed to send it to the board.
No, you sent it to Katrina.
It's getting cold, you know that?
I'll say it's getting cold in here.
You are cold?
It's getting colder every minute. Even this should have heated us up a little at turning in.
What are you going to do tomorrow?
I'm sweating over here.
Short sleeve.
Suggested, but a lot of schools in the
not why
area
I'm
are doing a
sweating.
2-hour delay. And I don't know why Medford canceled, but they did.
Wow.
Yeah, Did Middleton cancel?
No,
We're
unless
hardly
since I've been here, Desi has recommended it, but there are a lot of schools in the area that are delayed by 2 hours.
I'm also the school bus guy.
Schools, I think they said.
We've got a lot of schools going.
What?
I'm also the school bus guy. I take all the kids.
But do you got delays? I know we're not delayed.
No, very few. I've had a lot of superintendents call me, but we
Yeah.
haven't.
I think it depends on the town. If the buildings are older, they know
Medford
that
Maybe that's it.
They're worried about buses. They're worried about school buses stuff.
I just have to.
Running already?
gives
Well,
the schools
they
time.
get the new law, the EPA, you can only run them for 5 minutes. So, and some of the communities have a 55 temperature.
So,
55
yeah, we're just
degrees,
making a
which you'll
motion.
never get it up to 55 degrees tomorrow.
I bet a lot of buses going to be empty.
Yeah, there's going to be a lot of kids that don't go. A lot of parents are going to bring them up.
I know, you're insane.
All right, so I'm going to make a motion that the common driveway shown on the plan complies with the design requirements for all driveways set forth under section 6.3, and more specifically, the requirements applicable to common driveways set forth under 6.3.6 and that driveway will be a width of 12 feet with the turnaround as per the fire department and the, okay, so that's it, yeah, so we'll go with that. That's the first motion, right? Correct?
Motion is made. Is there a second?
Second.
Motion is made and second. All those in favor?
Aye.
Yes.
Yes.
Yes. I'll vote in favor also.
In honor of Mr. Fox, I'll abstain.
Okay, the second
Is
part
he
of the
okay?
decision is that,
You didn't come.
is there a second part here?
Yeah.
Yeah, the motion to issue the permit and authorize the use of the common driveway pursuant to site plan number, what is it?
Oh, the site plan is dated October 21st, 2016, and as revised through November 13, 2017.
December.
16.
December 13th.
Oh, December, I apologize.
The
December
condition
13th.
is that this is dependent on the approval of the Concom.
Yes.
Okay, that's the
And-
motion. Go ahead,
Well,
Barbara.
also, don't you
Yep.
want to, this whole thing about snow removal, maintenance, repair, and everything shall remain the
doesn't
responsibility of the,
the-
or will that be done through planning?
That's all in that. It is
That-
all in
that's
that
part of the
common
condo.
maintenance agreement, but you can absolutely say, because you can say you incorporate all of the requirements pursuant to
To
the common
6,
maintenance,
right.
which I submitted with the application. The application is part of the whole thing.
Okay. Yes, we'll add the,
Because if I may, can I just say one thing to the board, so you know? It is going to be a private way completely, so we're going to be responsible for plowing the street as well. So,
and also, yeah. under
And that'll
the-
be done pursuant to planning board approval, right?
oh, absolutely.
Okay. So add that to planning board approval as another condition.
Yes.
Okay,
Are you all set, Michelle? You get all that?
okay.
Motion is made, seconded.
Second.
Yep,
Vote.
yep, yes.
Yes, yes, yes.
Barbara was saying.
Yes.
Motion is approved, 4-1.
I very much appreciate your indulgence. Thank you.
Yes.
Thank you for speaking up, Mr. Stein.
Council, Merry Christmas.
Merry Christmas.
Yeah. Good luck.
You sure you're not making that up now, are you?
You know a little Italian, right? That means he's evil, nothing bad.
Yeah, we're going to
I had to
be
give him a little
closing very
Italian speak.
quickly.
You know Italian.
Yeah. All right, the next thing on the agenda,
Otherwise, we'd have to cut the hill.
Would be better that way.
Attorney Mann, can you
Counsel.
take that outside? We still have,
meeting's still going on, please.
I'm putting my coat on first. Again, happy holidays, everybody.
same to you.
Next thing on the agenda is an administrative item under item number 4 on the agenda, and that's administratively been referred to town council. Is there any other business of the board?
Do we have to approve that? Or that's the end of it?
That's item number 4.
I mean, do we have to say anything about it? Like,
No.
do we have to vote, Barbara, or do
No.
anything for that?
No vote.
No vote?
Just referred to council. Is there any further business? There being no further business, the chair will entertain a motion to adjourn.
Okay.
So moved.